Welcome, everybody. It's great to have you. We're going to go ahead and get started so we can only keep you for an hour. Thank you for joining us for Inner City Law Center's conversation about evictions in Los Angeles. We're very pleased to have three of our fabulous Inner City Law Center attorneys with me here today. We're going to have a bit of a conversation. We're going to hear from each of them as we go through this hour together. There's a few opportunities for you to plug in as well. You will see you have a chat function here on Zoom, and anything you put in that chat can be seen by all of us and all of the other attendees. So feel free to comment or react, say wow, or say that's amazing, or disagree with something, or share your own experience in the chat in the chat bar. So a Q&A button on your screen, and if you click on that and enter a question, that won't be seen by everyone, but that will come to us here on the panel, and we'll be able to hopefully incorporate your questions and answer a number of them throughout the panel today. So please don't be shy. Feel free to reach out with your questions or to share reflections or comments as we're going through our time together. I want to begin, if I may, by just setting the stage a little bit before I introduce our three fabulous panelists today. And if I can, by starting with a statistic that LHSA, LA Homeless Services Authority, released in early 2020. So this is pre-pandemic. In Los Angeles County, they estimated that 207 people on average every day moved out of homelessness in Los Angeles. They managed to find a pathway into housing. Each day on average, 207 people. But each day on average, 227 people became homeless. That disconnect between a smaller number of people moving out of homelessness and a larger number of people moving into homelessness describes why we have, and why we have had for some time, an escalating homelessness crisis in Los Angeles. And the situation has only gotten worse with COVID. Census Bureau estimates that 17% of renters nationwide are behind on their rent. The Urban Institute recently estimated that over 9.4 million renter households are behind on their rent nationwide, owing collectively over $50 billion in back rent. When you talk to people on the streets, the top two reasons that they usually give for the precipitating factors that led to their homelessness are one, that they were evicted, and two, that they couldn't afford to pay rent. Obviously, those two reasons are intertwined in various ways. So for all of those reasons, Inner City Law Center for many years has focused on homelessness prevention, on advocating for more robust homelessness prevention systems and policies and programs and support services, rental subsidies, social workers, social services, lawyers on the street, and also providing those services ourselves. And so I'm very pleased to have with us today three of our fabulous attorneys who are on the front lines, on the ground, day in and day out, representing tenants who are facing the horrible situation where they are in danger of losing their homes due to eviction. And so I'm going to introduce each of our panelists. I'm going to ask them to talk a little bit. And as I mentioned, for those of you who have joined us just recently, please feel free to throw your comments into the chat box or your questions into the Q&A so that we can address them as we move through the program today. So let me start with introducing our three fabulous panelists, starting with Donella Green. Donella is a native Californian, grew up in the Central Valley in Merced, went back east for law school at Fordham University School of Law in New York, and then worked in New York both as a public defender and a legal aid attorney for a number of years before coming back home to California and back to join Inner City Law Center. She currently serves as the supervising attorney for Inner City Law Center's Preventing and Ending Homelessness team, which is a broad, a team that has broad responsibility. That team both works with people who are on the streets or in shelters and struggling to get into housing, and people who are precariously housed and struggling to remain in that housing. So welcome, Donella. It's great to have you with us.
Thanks, Adam. I'm happy to be here.
Secondly, I want to introduce Cherry Mulaguru, who is a relatively recent addition to Inner City Law Center's team, now celebrating her 1-year anniversary with us. She is also a native of, grew up in San Diego, so not in Los Angeles, but in San Diego. Went to my alma mater, which may be all you need to know about her. She went to Pomona College, but then went on back east to Harvard Law School, and then came out and joined Inner City Law Center after graduation as a housing justice fellow. And so she's been with us for a year. career and hopefully just at the very beginning of her long and illustrious career with Inner City Law Center. She is with what we call our Tenant Defense Project, which is a team that does a number of things, but the bulk of that work is representing tenants who are facing possible eviction from their homes. So Cherry, welcome and great to have you with us today.
Thank you so much, Adam.
And then third, we have Kaimi Wenger, who grew up all over and went to Columbia Law School, clerked back in the Eastern District of New York, worked New York City law firm for a number of years, and then served as a law professor at Thomas Jefferson School of Law in San Diego before coming north and joining Inner City Law Center. He is a senior staff attorney with our tenant defense team, which is the same team that Cherry is on. So Kaimi, welcome, and I'd like to start with you, if I may, and ask you to share a little bit. A question I get a lot in this area is, there's a lot of talk about protections that have been implemented in light of COVID. People talk about various moratoria that are in place. And so some people are in the impression that everything must be fine on the eviction front. Those things aren't happening. Obviously, we see clients and tenants every day who are losing their homes. Can you talk a little bit about what you're seeing in that respect and maybe talk about a case or something that you've worked on recently?
Absolutely. And thank you, Adam. Thanks to the co-panelists. This is a great group. So to your question, the one case I can think of which illustrates this, and we see a bunch of these, but one case that we had recently, I'll call Mr. Martin. We use pseudonyms for our clients in these discussions. Mr. Martin is a disabled 77-year-old veteran who lived at the same rent-controlled apartment for 25 years. And then at the start of 2020, the landlord decided they wanted him out so that they could knock the building down and put up luxury apartments instead. He's lived in Koreatown, which is one of those areas where now they're putting up luxury apartments. Mr. Martin has some disabilities and didn't fully understand the court process. He went to court and he did file a piece of paper on his own, self-represented, a motion that he explaining that he was disabled, he didn't have any place to go, he wanted to stay. The court did not grant that motion and instead allowed the case to go forward, and Mr. Martin was days from being locked out of his apartment. There was a sheriff's notice put on the front door saying, "We are going to be back in a couple of days to permanently lock you out of your apartment." At that point, he came to Inner City Law Center. So at that point, we took a two-prong approach in Mr. Martin's case. The first thing we did is we filed a motion under the CDC order, which effectively bought a couple of months. The Centers for Disease Control and Prevention has issued an order which pauses a lot of eviction proceedings, but only if you raise it. And so we raised the CDC order and we bought him a couple of months, at which point we looked at the underlying lawsuit and realized it never should have gotten this far in the first place. This is what they call a no-fault eviction. He hadn't done anything wrong. He hadn't failed to pay rent. He wasn't throwing wild parties. He was just in a building that the landlord wanted to change, and therefore they wanted him out. Under the Los Angeles Emergency Moratorium, or well, so-called moratorium, these no-fault evictions are supposed to be not happening. Landlords are not supposed to be able to bring them, but the landlord brought this anyway, and the judge didn't stop it. And if we hadn't stepped in when we did, Mr. Martin would have been locked out. What we did do, once we realized it was this kind of case, the Los Angeles emergency statute does also include penalties for violation, but those also are not self-enforcing. We wrote the landlord's attorney and we said, this is a violation of the statute. If you don't withdraw this lawsuit, we will go forward seeking some of these penalties, which include up to tens of thousands of dollars in penalties. And at that point, the landlord agreed to dismiss the case. So what I see in Mr. Martin's case, we hear the word moratorium a lot, and some folks think, well, everything's on pause. No one's going to be locked out. There are rules. No-fault evictions are not supposed to go forward. Evictions for pets are not supposed to go forward in Los Angeles. Evictions for landlord move-ins are not supposed to go forward, but none of these are self-enforcing. Landlords are trying this anyway, and courts aren't stopping them from doing it. And unless the tenant has an attorney, they're liable to be locked out despite the presence of the so-called moratorium.
Thank you, Jaime. I think that recognition that these protections are not self-enforcing and that somebody has to raise them and jump through the various hoops and do it in a way that the courts can respond to is a very important comment and insight. Terry, can I kick it to you a little bit to talk about maybe a recent case that you've worked on, and in particular, if you have one where maybe tenants have lost work or lost income due to COVID and now are struggling with that, who these protections are designed to protect and designed to keep in their homes, and yet they don't automatically do so. That would be great.
Yeah, absolutely, Adam. I think it fits in exactly with Kaime's point. As Kaime said, it's a so-called moratorium, right? Tenants will hear the word moratorium on the news or, even from us, right? And they expect that evictions aren't moving forward, but defaults are happening every day. Lockouts are happening every day. I have multiple cases where the tenant wasn't able to pay because of COVID and was almost locked out because of a default. I got a case just last week where the tenant got a sheriff's notice to vacate that was set to expire yesterday. So she could have been locked out as early as today. And this is a tenant who, she was working in construction. She lost her job because of COVID. She isn't getting unemployment or anything. She has no income right now. And the two things that are really shocking here is first, that the tenant never got any paperwork from the court. The landlord sued to evict the tenant based on April and May rent of last year. So she never got the complaint. The court even noted that the landlord had never filed a proof of service. So she had no idea that this eviction was moving forward. And, I mentioned it was April and May rent under the COVID-19 Tenant Relief Act. The landlord is supposed to give a tenant a 15-day notice to quit instead of the regular 3-day notice to quit, notice to pay rent or quit. And it's supposed to include all of these tenants' rights protections. It's supposed to come with an unsigned declaration of COVID-19 related financial distress that the tenant can sign and return to the landlord to let them know, I'm not able to pay because I've had some income loss because of COVID or increased expenses because of COVID. The tenant got none of that. She got a 3-day notice to quit for those months. The law explicitly says a notice that doesn't comply with this, with these requirements can't be the basis of an eviction or a default. Regardless, she got defaulted on. A writ of execution was issued in April. And, on top of it all, the landlord goes to her apartment at the end of April and with a phone and says, give me your information. I'm going to sign you up for the rental assistance program. So this is after they've gotten a writ of execution, and the rental assistance program does cover April and May of last year as well. So this is a tenant who, she's really one of those tenants, just like you said, Adam, it's really meant to be protected by these laws. And she still could have been evicted as early as today. And, we went in ex parte yesterday, had the execution stayed, and the hearing on the motion to set aside the default is next week. But I think it's the same point that Kaime was making, right? There are these protections in place. They're meant to protect all of the tenants, all the tenants who weren't able to pay because of COVID. But where the tenant doesn't have representation, doesn't have individual time or capacity or knowledge to enforce them, they're not being enforced. The landlords aren't following the rules, even in giving a 15-day notice, which is explicitly required under the law, and they're still getting defaults and they're still getting lockouts. So I think it is really often overlooked.
So Kaime, if I can kick it back to you for a second, I know we've had a number of cases where the tenants have sort of bent over backwards and our clients have bent over backwards to try to comply. Right. But they're not lawyers, and these are complicated rules for us, right? We spent a lot of time trying to figure out the various orders and how they fit together and what protections apply and what you have to do to realize them. Can you talk a little bit about what you're seeing or what we're seeing generally with respect to tenants who are trying to comply?
Absolutely. I had a recent case with a tenant who we'll call Mr. Francisco. Mr. Francisco tried very, very hard and did a lot of things and almost got locked out anyway. Mr. Francisco is a monolingual Spanish speaker. He lives in Hollywood and works as a makeup artist, where he's worked for 15 years in the entertainment industry. Like many independent entrepreneurs in Hollywood, he became unemployed when the pandemic hit and they stopped filming things. So at that point, he began sending the landlord letters, very clear, though they were not in proper grammar, but very clear in his attempted English, explaining that he had lost work and was unable to pay rent due to the COVID-19 economic effects. The landlord filed an unlawful detainer case anyway, and as a result, they served him with these papers, including the 15-day notice and the blank declaration of COVID-related financial distress, which tenants in theory have to sign and return to be protected under the statute. When the case was going forward and there was a lockout order, the landlord claimed that they had never gotten this form back from Mr. Franco. So we went in ex parte, we got a stay and asked for a further hearing, and we went in expecting to make an argument. The argument I was expecting to make was that due to the fact that he had sent these letters and due to the fact that he didn't speak English, he had effectively given the same sort of notice, and it should be considered as if he had given his COVID-related financial distress declaration as set out in the statute. It would depend on what the judge would think, but we thought that was a reasonably strong argument. And then it came out at the hearing that he actually did send back the official declaration. And the landlord went forward with the unlawful detainer anyway. And we had been ready to argue that his unofficial letters should be considered the equivalent, but he had actually, despite these hoops that he has to jump through, despite the fact that he doesn't speak English, he had jumped through the hoops. He had done these steps, and the landlord was trying to evict him anyway, and they almost got away with it. If we hadn't dug further in this hearing, they would have potentially evicted Mr. Francisco, despite the fact that he had done everything he was required to do under the statute. One other thing to mention here, and I may, if I can share my screen, if I can figure out how to do that, because I want to show what the documents are that Mr. Francisco, how do I share my screen? I don't, oh, share screen, the big green button. So are people seeing this document? This is a redacted copy of the answer that
Yes.
Mr. Francisco filed. And it's heartbreaking because when you look at it, this is what would get him in trouble. This is a very technical legalese sort of document, and it says several things, but importantly, it says you have to check general denial or specific denials. He didn't check either one. Instead, he wrote out in very clear attempting, I haven't paid my rent since April 2020. I am self-employed. I'm not getting any pay. I have, down here he says, I have no money at all due to COVID-19. It's very clear what he's trying to say. This is a self-represented tenant doing everything he can to try to explain what's happening. This document would have gotten him evicted. The court was ready to say he didn't check either general denial or specific denial, therefore he is denied nothing in the complaint, and therefore we will evict. I'm gonna unshare now. So yeah, it really illustrates the incredible number of hurdles that are placed on tenants. You have to file an answer within 5 days. You have to check the right boxes. You have to say the right magic words, which is a little ridiculous. He's saying, I'm self-employed, I don't have money. What he's not saying is CDC order. He's not saying Los Angeles local emergency statute. And without saying those magic words, he would have been evicted. And that was why we had to step in as an attorney, showing the importance of tenants having attorneys in these cases.
So Donnell, I want to bring you into this. I know that the PEP project sees a lot of pretty horrendous behavior by landlords in a lot of these sorts of situations. Can you talk maybe about some of what you're seeing?
I absolutely can. I first just wanted to make the point. I think both Kaimi and Sherry have made it absolutely clear of the necessity of right to counsel, right? The need for having representation on eviction cases. I'm going to switch the tone a bit and share just some of the disturbing behavior that we've seen from landlords during the pandemic. So I'm going to discuss just something that happened with a client that our team represented. We'll refer to him as Mr. Dixon, but he came to us. He did not have an eviction pending against him, right? He didn't even receive any sort of notice or anything official that would start the process for eviction from his landlord. So he reached out to Inner City Law Center literally the day before he was planning to vacate his unit. And I spoke with him on that day, and he told me, my landlord, he told me that I have to leave, so I'm going to go. And we talked more, and then I informed him, you don't have to leave. You can stay in your home. We're in the middle of the pandemic. The landlord has not done anything here. He has not gone forward with that process. You have a right to stay in your home. That conversation there it's illuminating, right? It shows you that eviction defense is absolutely crucial, but also tenant education and empowerment is very necessary, right? Just the basic rights and the basic process when it comes to eviction. So he was under the impression that he had to leave because his landlord told him so. And connecting with us was the first step in educating him and empowering him and letting him know, no, you don't have to leave. So starting there, I reached out to the landlord, reminded him of that process, and also demanded that he stop harassing my client, which he had been doing via email and text message, telling him that he had to leave. So this landlord, very, very bold, not atypical, said no. And he was absolutely going to have my client illegally evicted. He was going to send someone to have him physically removed from his home, and that there was nothing that me, an attorney, could do about it, right? So imagine how he was speaking with Mr. Dixon. Imagine the aggression, the tone, and the way that he approached this situation with Mr. Dixon if he's talking to me, an attorney, this way. So immediately, we jumped on. I had 3 other attorneys assisting me with this case, and I'll tell you more why, just to get him safe and secure in his home. So just as he said, he did send someone to the unit the following day. That person came and physically took Mr. Dixon out of his home, and he removed all of his belongings, had a locksmith come and also changed the lock. Immediately, we called the police. They came out, and an attorney on my team went out to Mr. Dixon's home to assist. So after several hours, after lots of back and forth, we were able to get Mr. Dixon back into his home and had the locks changed. And we had a conversation with police, reminding them of the appropriate process, that the landlord had not followed that process, that what the landlord was doing was in fact illegal, and that we would be moving forward with restraining orders against both him and the person that came to physically remove Mr. Dixon from his home, which we did do later that day, and they both were successfully granted in favor of our client. So I mean, landlords are going through the process sometimes, yes, but I wanted to make it clear that they are not as well, and they are taking extra legal measures to remove our clients from their homes. They are harassing, in this case, physically assaulting and committing battery against our clients. And it's absolutely crucial that we both empower and educate our clients about what their rights are in these situations.
Thank you, Donella. Sherry, can you add to that in terms of what you're seeing?
Yes, definitely. I think it's exactly as Donella said. There are these protections that are meant to keep tenants in their homes. Landlords want to find other ways to advance their interests. They want to find other ways to get these tenants out. That can sometimes mean locking the tenant out outside of the court process, and it can also mean harassment. And I think we've really seen an increase in the harassment that tenants are experiencing. I'll refer to a tenant as Miss Bryce, but I was previously representing her. You were talking, Adam, earlier about tenants who've done everything, right? They've done everything that they're supposed to do. And we often see tenants who don't do that. For example, a monolingual Spanish speaker who doesn't know they have to return the declaration, which of course is fair as well. But This is a tenant who her hours were cut back in June 2020 because of COVID. She made every attempt to continue to pay rent, went above and beyond. And then when she wasn't able to pay in full, she preemptively sent the landlord declarations of COVID-19 related financial distress, even before getting any notice to quit. She did that every single month she couldn't pay in full. She continued to pay 25% of the rent. And then the landlord's reaction is to get extremely upset with her. He accused her of sending threatening letters referring to the declarations. He was like, you're just saying you can't pay. You're not talking to me. He was harassing her. He was stopping by the unit. He was calling her, and he explicitly said that he was raising her rent $775 because she wasn't able to pay because of COVID. And he knew that, she had communicated that to him. And we got this case dismissed. But my point is really the same as Donnella's, that we're seeing this harassment happen. And I think tenants do need more protection from this kind of harassment. I have cases where tenants have moved out because they haven't wanted to deal with the harassment. They haven't wanted it to escalate. I had a tenant who said, I have to move. I have an 18-year-old son. I'm worried about, him getting angry because of all this harassment. And, it's tenants need the protection. It means, having someone who can advocate for you, who can send an anti-harassment letter, who can handle an unlawful detainer if there is one. But, as Donella said, it also means tenants finding out about their rights. It means tenants organizing, and, anything that can be done to equalize the power dynamic a little bit, I think is really important in preventing and stopping this harassment.
Adam, there was a question that I saw in the Q&A that I wanted to address, just taking it back to Mr. Dixon's case. Someone had a question about what the experience was in terms of LAPD. So I wanted to address that. And I mentioned that there were 4 attorneys that I had working with me on Mr. Dixon's case. And part of that was because it took 2 attorneys making several calls to different law enforcement agencies to try to get them out to his home to respond. So as 2 attorneys were doing that, the other attorney was prepping the restraining orders, and then I was on the phone myself. So we've seen very slow response time, unfortunately, from the police department. In fact, Mr. Dixon had let us know that he had called the police several times before to only have them not respond. So, and it took 2 attorneys contacting to have someone actually come out and assist with his situation.
Can you talk, Donella? Also, there's some questions about what are the possible repercussions of landlords doing these things that are clearly illegal? When we're involved, we're often able to stop the behavior and stabilize the tenancy. But more generally, are there repercussions for this sort of behavior?
There absolutely are. And with the new protections that are in place, there is a private right of action that our tenants can move forward with against landlords for financial penalties that'll be assessed against them. And that's absolutely something that we are considering doing in this case and other cases. I also wanted to just briefly discuss that restraining order process more generally, right? So with the cases that my team has been working on, I mentioned that we've seen a lot of tenants that are coming to us facing just disgusting, outrageous behavior from the landlords. There's assault, there's harassment, both in person, via phone calls, text messages, you name it, we've seen it. Another case that I wanted to just briefly mention that is really just, it's a horrible example of the worst of what we've seen. I'll call him Mr. Allen, but he actually came to us because he did have an eviction pending against him. It was later dismissed because it was based on an illegal notice that the landlord was well aware of and had been informed by HCID to actually retract that notice, but he did not and decided to move forward instead. So this landlord went so far as to have the attorney working with him get involved in the illegal behavior. One night, the attorney working closely on this case got a frantic call from Mr. Allen, and he let him know that the attorney was there at his door in the middle of the night with someone else, pepper sprayed him, took him out of his home, and he fled. he fled for his life, right? At that point, he had no idea what was going on. As far as he knew, there was this eviction happening. We didn't have any upcoming court dates. There was nothing moving along. But this landlord had made it pretty clear to Mr. Allen from the beginning that he was going to do whatever it took to get him out. And he definitely followed through on that. And I will say, I have seen pretty bad behavior from landlords, but the fact that this was an attorney participating in it completely floored me, right? And imagine if Mr. Allen had been navigating this process on his own, right? It really is, it still troubles me to this day, but I just wanted to stress that it's important that we connect with tenants, both when they are facing the eviction process and also if they're dealing with bad behavior from landlords. It's important that we get in front of it and push back and fight back and make sure that an eviction doesn't happen and make sure that their rights are being enforced.
And that attorney has been reported to the state bar.
Oh, absolutely. He's been reported to the state bar. We've taken several measures within that specific court case against that person, but we're absolutely handling it to the fullest extent that we can.
So let me ask us a couple questions in the chat about sort of scale of issues and about the fact that most people don't have representation. You know, in a normal year, there's about 40,000 unlawful detainer eviction actions filed in LA County. We don't quite know what the scale is right at the moment, at least I don't. Some of you might. One of the questions that's coming up in a few different ways in the chat or in the Q&A is about the CDC order and the recent press about various decisions either upholding or striking down or threatening to strike down the CDC order. Can any of you speak a little bit about what implications those court challenges are having in Los Angeles?
Yes, so the CDC order is a really important part of our toolkit. Basically, it's how we stop lockouts that are about to happen. And then we go in and we file motions under CCP 473 or other things to attack the case. So when I started doing this back in September, landlords in Los Angeles made constitutional challenges. They said the CDC order is an unconstitutional taking, it violates the Commerce Clause, all of these other sorts of things. And those claims were rejected by the state courts in Los Angeles that heard these cases. Landlords nationwide have been making similar arguments. And in one case in Washington, they got a court recently to say that the CDC order was unconstitutional. That has been stayed and is going to be appealed. I don't think it's going to affect our cases here. At the very least, I can say that no Los Angeles Superior Court judges have rejected the CDC order as unconstitutional in any of the cases that I've brought in front of half a dozen of these judges. And let me actually briefly talk about how the CDC order interacts with the other protections, because it's a complicated mix. Cherry talked about state level protections. At the very least, if you're in Los Angeles right now, there are 4 levels of protections. There's a city statute. The city statute prohibits several types of evictions, including evictions for non-payment of rent if you're COVID affected, which is basically everybody, evictions based on unauthorized pets, unauthorized occupants, no fault. All of those are prohibited under the city statute. There's a very similar county statute. So if you're not in LA proper, but you are in Long Beach or Southgate or in unincorporated Los Angeles County, the county moratorium is what protects you there. The county moratorium is a little more limited in some ways. It right now extends through June 30th, whereas the city moratorium extends through the end of the emergency period plus 90 days. In addition to that, the state has said if a landlord is seeking to evict based on COVID rent, they have to give a blank declaration to the tenant to let the tenant say that they've been affected by COVID. And finally, the CDC has said if a tenant gives a declaration, certain things that they make less than 100,000, that they've been affected by COVID, that they can't be evicted. So those are our 4 levels of protection. we are watching them, for instance, for my clients who live in Southgate or Bell Gardens, I'm watching to see whether the county moratorium gets extended, because if that doesn't, that's going to affect those clients a lot. And in addition, the 4 levels of protection do create a moderate amount of confusion. Tenants aren't sure how they're protected. Judges often aren't sure which statutes apply. And so we have to dig in and find out what jurisdiction applies and how to go forward with it.
So that really brings me back, Donella, to your point about a right to counsel. You know, there's a movement throughout the United States to establish, similar to what we have in criminal cases, where if someone's facing eviction from their home, they should have a right to an attorney to represent them through that process. And I think hopefully the audience is hearing from all of you, why that's essential and why that's so important. And Washington State just, created that right for everybody in the state of Washington. New York City, a number of cities have created it. Can you say a few words from your perspective, Donella, about why that's so important and what you're hoping happens here in Los Angeles?
Oh, of course. And this is coming, my background you mentioned earlier. I worked prior to joining Inner City Law Center as a public defender, right, where everyone is entitled to legal representation on matters. And as you all have heard, obviously the law has been overly complex, especially now during the pandemic. But even before that, the eviction process generally is very difficult to navigate. And it's even more so difficult to navigate if you have a client like Kaimis who does not speak English, right? So they have that additional barrier on top of it. So it's extremely important that tenants be afforded an attorney in their eviction matters, because it is one crucial step in making sure that people remain in their homes and they're not put out on the street, right? It's one way that we can actually do work to combat the problem of homelessness that we're all advocating so fiercely against right now.
So I think as I see a number of folks are answering questions in the Q&A, which is great. I don't know if those are then accessible to everybody. It looks like they may just be accessible to the person who asked the question. It doesn't look like it's posted somewhere. So just something to keep in mind as you're answering stuff, if we want to also mention it to the group, if it feels like it's something broader. One of them that does seem a bit broader is someone asks, when the moratorium is over, or the moratoria, various protections are over, what protections will tenant have if they still cannot pay the back rent? So I assume this is mostly relates probably to the state law, but if somebody wants to say a few words about what happens to people who have protections right now, the law says they don't have to pay that, they can't get evicted now if they can't pay the rent. What happens to that back rent over time?
I can answer it.
Right.
Okay, so I think it depends on who you ask. The state law says, it's right now set to expire June 30th. For the state law is a little bit complicated about how it handles different time periods. From March 2020 through August 2020, all of that money, if the tenant didn't pay during that time, it's converted to COVID-19 rental debt. And then this is if the tenant returns that declaration that Kaimi was talking about. And then for September of 2020 through June of this year, the tenant also, on top of doing that, has to pay 25% of the rent that came due during that time. So, if all of this happens, all of the rest of the money that the tenant owes becomes COVID-19 rental debt. It can't be the basis of an eviction action, and the landlord could sue for it in small claims court. The rental assistance, there's a little bit of a complication there. But they can sue, the landlord can sue as early as August 1st. So that is obviously a very tight deadline. There are different deadlines based on the different local protections that Kaimi was talking about. Some cities, like I believe Pasadena, says 6 months after the local emergency period ends. And then LA City says 12 months after the local emergency period ends. So it really depends where you're at, and it depends what level of protection we're talking about.
Great. And another question is about, it's a little bit nuanced, but it's about the interplay of the city and county protections and whether or not, how do those two interface with one another?
So if you're in, the county says it affects everyone in Los Angeles County unless they're protected by a broader statute. So if you're in LA City, the city statute is broader than the county statute. So you are protected by the LA City statute, but you don't have to worry about the county statute. But if you are in unincorporated, and there's a surprising amount, everybody knows, you've got cities, you've got Los Angeles, you've got Long Beach, you've got Pasadena, whatever else. What a lot of people don't realize is there are large stretches of what people think of as Los Angeles. And if you're writing a letter, you write John Smith on 80th Street in Los Angeles, but that's actually unincorporated. You may live in some unincorporated portion. And so a lot of people do live in, especially in South LA and in East LA, there are these unincorporated areas. Those are protected by the county statute as well. A couple of other things to briefly mention. One of the comments talked about undocumented tenants. Undocumented tenants are definitely facing harassment based on immigration status. And also this is highly illegal under the California statute. Under 1940.3, 1940.35, it's explicitly illegal to make threats based on a tenant's immigration status, and yet we're seeing landlords do this. And on a broader point, those are it sort of is a microcosm. The tenants we're not seeing clients from Beverly Hills. We're not seeing clients from Santa Monica, rich areas. What we're seeing are tenants, especially from poorer areas, but areas that have been subject to gentrification. And so we're seeing tenants in Koreatown, we're seeing tenants in Westlake, we're seeing tenants in parts of South LA that are near USC. And landlords are thinking, this is my chance. I evict this long-term tenant. Now I can put up a big new shiny building and charge $3,000 a month for rent. And so we're seeing a lot of that happening.
So one case that, recent case, like in the last month, that's really stuck with me, Kaimi, and I know you had some connection to this case. I don't know who actually the lead attorney on it was. And not because it's the most horrendous in terms of sort of the behavior, but just sort of the ridiculousness of it sort of highlighted for me. And I can see you nodding your head. I think you know what I'm going to ask about. I think of it as the pumpkin case.
Oh, yeah.
Can you share a little bit about that case?
This is, we'll call them the Linus family. So the Linus family, this is their second unlawful detainer filed against them. First, the landlord went after them for alleged non-payment of rent, and my colleague Tony Bonadies was assigned to it, and he got the lockout stayed. There was a lockout order ready to go. He got that stayed, and he went to court and was able to show that they didn't actually owe the rent. It's in many cases, the non-payment of rent cases are the easiest to defend right now because of the COVID regulations. Then the landlord filed a second unlawful detainer alleging lease violations. And the lease violations included things like, you have pumpkins in the front. So there was a common porch area, and during Halloween, the tenant grew a small pumpkin and also had another pumpkin out there. Those pumpkins were seen as a lease violation. Christmas lights, lease violation. The whole thing, landlords manufacture alleged lease violations now as a way to get around the restrictions on the more complicated hoops that they have to show to prove a non-payment case during COVID. So yeah, the fact that the tenant has pumpkins in the front suddenly becomes a lease violation that must be cured, and the only way to cure it is to throw this tenant out, which is ridiculous.
So we have one question from Grant Reilly. He's a long time involved with Inner City Law Center, supportive of us in various ways, saying that he runs across some of these issues in his practice, and he'd love to see some briefing we have about those 4 layers of protection. So I assume we have something that we can share.
Absolutely.
Along those lines. Just flipping through the various questions and comments here. What else, Vanilla, Jerry, Kaimi, what else do you want to make sure people are thinking about?
Oh.
What about the oh, go ahead, Kaimi.
One thing that has changed the game a little bit is the rental subsidy money, because this gives us a way to put a carrot and a stick out there. So in one case that I had recently, another alleged lease violation, they said that the tenants had too many cars parked in front, which is a ridiculous case. And obviously the landlord is just trying to evict this family to move in and, to raise the rent. People, I don't know if people are aware, in a rent controlled apartment, landlords can raise the rent 3%, 4% per year. But if a tenant leaves that apartment, suddenly the landlord can raise it to whatever they want. So landlords try to do that sometimes. So in this case, the landlord had this bogus sort of claim about too many cars in front. At the settlement conference, I mentioned that the tenants had applied for the rental assistance, and the landlord attorney paused, and then he said, "Let us know if they're approved, and if so, for how much." And then he emailed me afterwards and said, "If your guys are approved for enough money, we'll tell our clients to drop the case." So yeah, landlord attorneys are realizing that it's helpful sometimes for their clients to take the rental subsidy money. So that changes our ability to negotiate, and it gives us the ability to say to the landlord, do you really want to kick this family out, or do you want to take right now, the county or the state is offering 80% of the back rent, or up to 80%. We'll see what the final amounts are. So if the tenant owes $10,000 in back rent, I can tell the landlord, if the client was approved for the full amount, I can say, look, here's $8,000 in state money. Why don't you take that and drop the case? And that's a powerful settlement tool.
And then the landlord needs to agree to not pursue the other 20%. That's the,
Right.
Gotcha. What about in court procedures have changed quite a bit with COVID. Can one of you speak a little bit about how that's been for our clients? Like, what are the upsides of that, and what are the challenges of that as things have moved more remote?
I can make a quick point if someone else wants to jump in. The case that I was talking about, the tenant who had the notice to vacate, sheriff's notice to vacate, set to expire today, or set to expire yesterday, she could have been locked out today. She went down to the Inglewood court, and she tells me, I was in such a panic because the court was closed. I couldn't get in. I didn't know what I had to do. And it really, there is some benefit, I'll say, tenants who weren't previously able to get to the courthouse easily, for example, tenants who have a disability of some kind, there's some benefit there in being able to call the tenant and then call into court. But there's definitely like a barrier in both tenants not knowing what the court procedure is now, that you have to make an appointment to go in, in some courthouses, but also that there is that technology barrier, right? There's tenants who aren't able to sign electronically, like I have to send them things to sign electronically. But that's tenants who are represented, tenants who don't have attorneys and don't know how to use this technology, don't know how to call into court, there really is an increased barrier there. Kaimi or Darnella, if you want to jump in.
Well, I mean, just to echo everything Cherry said, that it's a plus and a minus. For someone who's in a wheelchair, it may be actually easier, but for a lot of our clients, the digital divide is real. They don't have access to a laptop and to Wi-Fi and to internet, and it creates a new hurdle for them.
Great. Let me just say for our audience of folks who's listening, I've been trying to pass your questions along, and I know folks have been looking at them, but we've got quite a number. And so feel free to repost. If you have a question that you asked a little while ago and didn't get it answered, feel free to throw it up again to make sure we didn't miss it as we're moving through. We do have a question about the role of mental illness, and when we see mental illness issues, how do we as Inner City Law Center navigate that, and what does that look like?
I can definitely speak to that. Just to give more information about the PEP team, the Preventing and Ending Homelessness Project. Our team, the way that we're designed is that we work closely alongside homeless service providers, where our clients receive additional services that could be mental health treatment, housing navigation, assistance with connecting to employment resources. And then our team provides the legal piece to remove any barriers that are preventing that person from remaining in their home or getting into stable housing. So the attorneys on my team, we work a great deal with mental health providers, caseworkers, with the end goal of just advocating for our clients. And I think what the attorneys on my team have seen is there has been it's been a very difficult time. I mean, I think that's obvious. It's been a difficult time, the pandemic, for all of us, but especially so for our clients that are suffering from mental illness. And it's especially been hard to connect with them. Prior to the pandemic, my team, we spent a lot of time just out in the community at various shelters or other places where we could connect with our clients, and taking out that piece has been, just challenging, both for the team and for clients. And we've been able to navigate and go into those spaces again. But we really have seen, it's just been challenging, and we're doing all that we can to continue to advocate and provide services, and also be just a source of support and a resource for all of our clients, and especially those suffering from mental illness.
Great, thank you, Donella. So we have a comment in the chat, or I guess it's in the Q&A, about filing of affirmative cases as a strategy within this. That's something the Inner City Law Center, we definitely see a lot of overlap between our affirmative habitability cases, right, suing slumlords, and the eviction actions that often bring a building to our attention, or we're sometimes in response to tenants complaining about conditions they face eviction. So we definitely see a lot of interplay there. Anything that any of you want to say about that interplay or that interaction? Okay. Connie, were you going to jump in on that? No. Okay. So let me just flag, though, it's a great sort of transition point to the fact that this is hopefully the first of a number of conversations that Inner City Law Center is going to be hosting with the folks who we work with, and our partners and our supporters. So we will probably have one at some point on our slum housing work in particular, and that'll be an opportunity to delve into those issues in more detail. So please keep an eye on your inbox and on however you get information from Inner City Law Center. I do have a few closing remarks I want to make, and I want to make sure people are out by 1:30. We always try to be good and timely. But any last comments from any of our panelists that you want to make sure people take away?
Write to your representatives, call your county board of supervisors representative, because June 30th is coming up, and we worry about what happens when these deadlines pass.
Great.
Anything, Donella or Cherry? You don't have to, but anything?
I just really want to stress and echo Kaimi's point. If protections aren't extended, the result will be devastating, extremely devastating for many people that will fall into homelessness. So do all that you can to continue to make sure that additional protections are extended.
Great. Cherry, any last words before I say a couple things?
No, I would just be echoing what they're saying.
Okay, great. So I just wanted to close with two things. One, to say thank you to everybody for joining us. And I see many familiar names in the comments here and in the Q&A and the list of who's attending. So it's great to see so many friendly names, and I don't get to see faces, but to see so many friendly names. I did want to, in addition to saying thank you, just call out a few ways that you can plug in and help and get involved and stay abreast. So the first is, and some of these have already been mentioned, but the first is to weigh in with your elected officials, anybody you know, about the need to continue these protections and extend these protections. We are not yet out of the woods on the dangers related to COVID. A lot of people are still struggling economically related to this pandemic as well, and we really need to extend the time to let folks get back on their feet in a meaningful way. Similarly, anything you can do to help us advocate for a right to counsel in eviction proceedings is incredibly helpful. And that can be as simple as following us on our social media feeds and reposting things that we post. That can be talking to an elected official, anything you can do to help amplify our voice and our positions on these things and add yours to them is much appreciated. I encourage you to visit our website and sign up for our mailing list if you haven't already done so that you can get updates from us. Encourage you to attend our next our next one of these with one of our other teams. We have an amazing, it's one of the joys of the work that I do is getting to work with the incredible people that I get to work with. And you've seen 3 of them here today. And we'll have another 3 or 4 for our next topic. It really is an incredible group of folks. And Kaimi and Donella and Terry, thank you for all that you do and for joining us and sharing your knowledge and your wisdom today. You can also volunteer and you can sign up on our website to volunteer as a lawyer. We're always looking for additional pro bono assistance, but also as a volunteer more generally. We have a program called homeful.la, which you can get to through our website or directly at homeful.la that has opportunities to plug in and help, even if you're not a lawyer or if you're not connected to the legal field. We're doing, for example, a backpack drive for a bunch of our clients as kids are going back to school. So we're looking for school supplies and backpacks and the like for that. I also want to encourage you to join us on June 17th, and details are on our website, but it's our annual awards event. It is free this year because it will be virtual again. So you can plug in and join us. It is a fundraiser, and we always appreciate support in that way, but you're welcome to just plug in and join and learn more about our work, or to spread the word and have others join us as well. We're honoring 3 amazing pro bono attorneys who have done a lot of work with us, particularly in the slum housing arena. And we're also honoring the ad hoc committee on Black people experiencing homelessness here in LA that put out a fabulous report that really highlights how challenging the situation is for the disproportionate number of African Americans who are on our streets, and has a list of policies, prescriptions, and things that we all need to be doing differently. So I encourage you to check out and join us on June 17th as well. But mostly just want to say thank you. And so we will be posting this recording. I assume it'll be on our social media, but also on YouTube and on in some way or fashion through our website as well. So thank you all for joining, and especially thank you again to Cherry, Donella, and Kaimi for sharing your thoughts today. Enjoy the rest of your day.